Well, welcome everybody to our virtual school law seminar. My name is Brandon Wright with Miller, Tracy, Braun, Funk, and Miller. And I'll introduce everybody else who's joined us as well today. But let me just first start by thanking you for joining us today to take some time out of your very busy schedules. You know, we are talking to you guys frequently and often, and we know that this is a difficult and stressful time for everybody right now. And so we appreciate you taking some time to join us today. And certainly, we hope that as we walk through things today, that we're giving you some tools in your toolbox to help out. I know sometimes these legal updates can be overwhelming and a lot to think about. And our hope is that we're trying to give you some important tips of things you need to keep in your mind, COVID related, not COVID related, and everything in between in our topics we're going to think about today. Let me quickly just share a little bit about our format for today. We're going to start with some quick hits from each of our panelists today on various topics that we think are important. And that'll take us through the first half of our workshop. And then the second half is going to be up to you. It's going to be just total Q&A where you can ask us anything about what's going on right now in school law, and we'll do our best to answer those questions as we go through things today. So we'll take questions throughout through the chat box. We'll really focus that Q&A on our second half after we've gotten through our topics, and that's our plan for today. We've put the link to the PowerPoint today there in the chat box, so feel free to take a look at those, and we'll move forward. But let me introduce everybody on our panel today. Like I said, my name is Brandon Wright, a partner with Miller, Tracy, Braun, Funk, and Miller. I'm joined also by my partners, Luke Feeney, David Braun.
Hi, everybody.
And our associates, Christensen, and our newest associate, Ellen Lueking. And we have to say congratulations, Ellen. Bar exam is done, is passed. You're with us now. We're so happy and proud of you, and I look forward to hearing from you all today. So, with that introduction, let me hand things off first to Luke, and we'll let you jump right in from there.
All right, good afternoon, everyone. Thanks for joining us. We're going to jump in with some OMA, FOIA, and a couple other open meetings and procedural issues. And I guess the comment that I would give about the Open Meetings Act and FOIA in the era of COVID is when we first started fielding these questions in March, our default was largely that if you're acting in good faith and with a genuine interest in health and welfare, you're probably going to be just fine, technical considerations aside. And I still believe that that is largely true. However, what we'll see from some of the opinions is that as we're approaching 9 months in, or around 9 months into the pandemic, the PAC has become a little stricter on some of the technical requirements. So, just the old college try is not going to be quite good enough on Zoom anymore. So if you look at your materials, we'll start with the requirements for remote meetings, which have been largely codified from the original executive orders. And these allow you essentially to have remote meetings more or less at any time during the pandemic. There are a few things I want to point out here. As you'll notice in this slide, board members' attendance via remote participation has to be verified. Now, I'm not at all going to suggest that you need some James Bond level code in order to verify a board member's participation. Certainly video conferencing is sort of self-verifying. You can see your board members. But if you have a board member who's participating remotely and all you have is the voice, you need some means to make sure that that is actually the board member. So, if that is a concern, pay close attention there. Moving on, there is a provision in the act that requires at least the chief legal counsel or chief administrative officer, presumably that's going to be the superintendent, to be physically present at regular meeting locations. However, that is unless it is unfeasible due to the disaster. So as the bulk of the state is currently under Tier 3 mitigation, having one person physically present is likely less of an issue, particularly if your county or area is experiencing a surge and there can be meaningful participation. Again, all votes must be roll call so that the public can identify who is voting. So voice votes on video conferencing simply don't work well, and they're no longer permitted. You are also required to keep a verbatim recording of your remote meeting. And in Zoom, that's fairly easy because you can do exactly what we're doing today, which is record the meeting and put it on your website. So today's conference will be available on our YouTube link in the coming days. And so school districts can do the same thing. You certainly don't need to use YouTube, but the tech has advanced in such a way that this is not as difficult as maybe we thought this was going to be. Another issue for remote participation, and this is a two-prong analysis. This is whether the public is in attendance or the public is not allowed to attend. So as of a few months ago, we had a number of school districts who were allowing the public to attend or to attend in limited numbers. And the act requires that the public who is in physical attendance must be able to hear the discussion, must be able to hear the votes, and must be able to identify what's going on when board members are remote. That same analysis applies if the public is not allowed to attend. So as I suspect many of you now are entering a phase where we will no longer have the public at meetings, at least for December and perhaps through the winter, there needs to be advance notice of a manner in which the public can watch the meeting and participate. What I mean by participate is they have to be able to hear the discussion, testimony, votes, and that can be done via offering a link or a call-in number. So let's talk a little bit about some of the OMA cases that have come up in COVID. The first one, this was a non-binding opinion, but the PAC held against a district that had a 100-person limit on their Zoom account. Now, many of you may chuckle and think that you've never had 100 members of the public attend a board meeting, but what we've seen in some areas is that opening meetings up on Zoom actually increases the number of people that will attend virtually. So you can no longer put a cap on that. Moving on to another case, this is less of a COVID-related case, but an important PAC opinion. This was a binding opinion. As you know, the Public Access Counselor can issue binding or non-binding opinions. Binding opinions are generally issued in more serious cases. This case held that a school district violated the Open Meetings Act by discussing substance versus, discussing the process of evaluation instead of the substance of evaluation. So the board went into closed session to discuss a principal evaluation, and discussing the evaluation itself is permitted, but the board went too far in that they discussed process rather than the actual substance of the evaluation itself. So this is something that comes up frequently with RIFs. If your district is looking at RIFs in the spring, you need to be very careful that if you're discussing an evaluation for the terms of placement on a RIF list, that is limited to the evaluation and that the process or need for a RIF is not a closed session topic. Another PAC opinion, this actually was a court case, not a PAC opinion, but similar. This is a FOIA case rather than OMA, the Better Government Association versus the City of Chicago. And in this case, the court held that board members' text messages and emails on private devices are subject to FOIA if they pertain to public business. Now, this is not, in our opinion, a change in the law. This is simply a good and pertinent reminder that doing public business on a private email or phone account does not shelter that from FOIA at all. I think that's been widely known, but it is worth a refresher with board members. Moving on to another PAC opinion. This is a non-binding opinion, again on a FOIA case where a village improperly responded to a FOIA request by failing to give the requester the list of the people that they banned from their social media account. It's a little bit of an odd case and likely had some interesting local politics behind it, but the PAC held that if you are blocking someone from your social media account, that the act of blocking is a public record that is subject to FOIA. Two final slides before I turn it over here to my colleagues. This is an act that has been in existence for some time, but we're beginning to see contractors and unions start to pay attention to this. So this is the Illinois Workers on Public Works Act. And what this holds is that in periods of excessive unemployment, and excessive unemployment is defined as the month after 2 consecutive months during which the unemployment has exceeded 5%, during that period, your contractors have to have a 90% level of employees who are laborers within the state of Illinois, meaning 90% of your contractors' employees have to live in state. Now, this is probably something that will affect districts living close to our borders with other states. But as we see some economic contraction and contractors are moving farther for work, this is something that districts should be aware of. Certainly the 2-month period under 5% is something we may, or exceeding 5% is something we may have for a while. So again, a statute that's been on the books for a while, but really hasn't received a lot of attention until lately, starting to pick up on something we thought you ought to be aware of. So as my 10 minutes rapidly draws to a close, I will turn it over to my colleagues.
So before you run away, Luke, we've got a couple questions that I'll ask you on a couple of topics you raised. The first question is, for a remote meeting, can a voice vote still be used just to open and adjourn the meeting?
My advice, well, I would just prefer you do a roll call vote on everything and avoid the issue entirely. For something as simple as opening or closing the meeting, I mean, I can't recall a meeting at which a motion to adjourn has ever received anything other than a unanimous vote. But I think I'd toe the line and just do all roll call votes until we're out of the woods.
Yeah, I think all means all in terms of that statute at this point. The other question is, are there any considerations under the Open Meetings Act for boards who are holding a truth and taxation hearing this month? Would these guidelines apply to a truth and taxation hearing? And I think that we've had some discussion before about some of those very special provisions and making sure that we're meeting the letter of the law. Any thoughts on that?
So I think you probably can hold other hearings remotely, but when those hearings have specific requirements, I think we're going to have to be careful. Certainly allowing someone to comment remotely at a hearing might need to be a little different than simply submitting an email for public comment. So we may have to think about a little more scheduled interactive meeting, but I do think there are ways around it.
Great. Well, we'll come back with some more questions at the end, but now it's time to turn things over to Christine, who's going to talk us through some data security and cybersecurity issues.
All right. Thanks so much, Brandon. I'll kick off here and talk about possibly the most frightening 10 minutes of your day here. So let's say you walk in Monday morning and you receive this lovely message here saying all files on each host in the network have been encrypted with a strong algorithm. It talks about backups were either encrypted or deleted. It advises you not to reset or shut down your computer. It advises you to contact an individual at the email address listed, and then it ends with the charming benediction of no system is safe. Now, after you're done freaking out about this, and you start to wonder, what am I looking at here? Well, you're looking at a message indicating that you've been a victim of ransomware. So let's talk about what ransomware is. Ransomware, unfortunately, is a type of malicious software or malware that prevents you from accessing your computer files, your system, or your network. And a hacker demands that you pay a ransom in order for those files to be returned. Unfortunately, it can be very simple to download ransomware. It can be so simple as opening an email attachment, clicking on an ad, following the link. And it's not just you that can access ransomware. It can be your employees, and it can also be your third-party vendors. A few years ago, Target was subject to a huge hack through a third-party vendor that's working on their HVAC systems. And so this can really come from a lot of different angles. So let's change the slide here. So once the malware is loaded onto the computer, it will lock access to the computer itself and the data and the files stored. And most of the time you won't even know your computer has been infected. And you will not know until you can no longer access your data or you see the messages like we've just seen demanding ransom payments. Now, it's really hard to emphasize just how expensive ransomware is. In 2019 alone, the FBI reported that there were over 1,700,000 total complaints related to ransomware, with total losses calculated at around $10.2 billion. And the average cost of a data breach was $3.86 million. And not only was this expensive in terms of money, but the average time to identify and contain a breach is 280 days. So when you think about your school calendar, imagine being without any of your data or network access for 280 days. And in 2019 alone, over 500 US schools were being hit by ransomware. So this isn't something that's limited to just Target or Walmart. This can hit schools as well. So let's say that you were to unfortunately open up your computer and see this message. What do you do? The first thing that you need to do is to activate your incident response plan. Now, you may not have a plan, your district may not have a plan. Today's a great day to start working on one. I've referenced here the National Institute of Standards and Technology. They have developed a PDF, it's about 80 pages long, that's entitled Computer Security Incident Handling Guide. That's a great place to start in developing such a plan. The most important thing to do in developing a plan, though, is to make sure that everyone knows from step one who has what responsibilities and who has what authority. But the most important thing to do once you activate that plan is to stop the attack. That means that you turn off uninfected computers and pull the plug. And once you've done that, you need to make sure to contact your insurance carrier and your legal counsel. The insurance carrier and your legal counsel will start gathering information. That will include such things as trying to figure out the scope of the attack, figure out whether any contact with the hackers is advisable, whether any reports should be made to the FBI or to the media, figuring out those next steps. They will also engage the vendors to figure out how, if possible, to recover the stolen data, and they'll provide coordination between the parties. But you may feel like I've skipped an important step. Yes, we're talking just about the emergency, but how do we prevent the emergency from happening in the first place? Honestly, it's those small and simple things that we hope that you're already doing. But it's such things as using strong, robust passwords, not sharing meeting links on social media or other public channels, keeping operating systems, software, and applications current. Also setting your antivirus and anti-malware system to automatically update and run regular computer scans. Now, if your computer is anything like mine, it seems to just exist to update itself. That's a good thing. The internet is constantly evolving, so are hackers. You need to make sure that your computer is up to date. And probably one of the most important things that you can get out of today, make sure that you back up your data regularly. Now, we've already talked about the fact that resolving these issues, if they can be resolved, takes around 280 days. Your district cannot be without data for 280 days. So you need to make sure that you're backing up that data. And most importantly, make sure to create an incident response plan. And not just create it, practice it. It's going to be a very hard 24 to 48 hours if you spend most of that trying to sit around thinking, do we have a plan? How does this work? Who do we contact? And it may go without saying, but make sure that that plan actually is in a hard copy somewhere. It's going to be very difficult to access that plan if the only copy is on a computer somewhere. All right, so let's conclude and talk about the Illinois Student Online Personal Protection Act. So this is something that is going to come into play July 1st, 2021. And if you haven't heard of this before, that's just fine. Up until this point, it was applicable to website operators. But beginning in July, public school districts and Illinois State Board of Education will have to comply with new requirements when it comes to the handling of students' covered information. Now, this falls into 4 categories that we're going to talk about very briefly here. First of all, are agreements. If you agree to provide any sort of student information to a website or an online provider, you need to have an agreement as of July 1st. And it needs to have specific provisions. Now, you may be thinking, we have those agreements. Make sure before July 1st to contact us or to go through the act and make sure that those required provisions are in that contract. And remember that those agreements may not be the agreements you think about that are 10-page paper copies. They may be those shrink wrap agreements as well, so make sure you can go back and find where those are. Second, transparency. Transparency is going to be huge after July. Under SOPA, each school district has to post on its website a clear layperson explanation of the data elements of covered information that the district collects. It also has to provide other information that can be readily available to the parents. Third is security. School districts will have to implement reasonable security procedures and practices that meet or exceed industry standards. If that's confusing, what are industry standards? The good news is that ISB is required to develop guidance on this topic. And finally, SOPA also requires that you provide increased rights to parents. That includes inspecting and reviewing their students' covered information, providing a copy of that information from the school, and they can even request corrections to factual inaccuracies. Now, like I said earlier, ISB is required to develop and make publicly available model student data privacy policies and procedures, so we're all eagerly waiting to figure out what those notices, procedures, and policies are. So stay tuned.
So, and I would say that last part, Christine, my understanding is they may even have some regulations coming out soon.
Correct.
That may affect that as well. We have a question here I'll pose to you before we turn things over to David. Back to your suggestion of not sharing meeting links on social media. Well, how does that comport with posting our board meetings online so the public can access that? Is there a way to marry those 2 ideas together?
I would certainly say that providing a public link to your board meeting is advisable so the public can be available. I think the concern is that when you are providing access to student information and other kinds of protected information, to just make sure that those are subject to additional security.
Yeah, I think the difference between a public meeting and private things like student
Right.
records is an important distinction.
Mm-hmm.
Very good. Well, thank you, Christine. We'll come back with some more questions in the Q&A, but I'm going to turn things over to David now.
Thank you. So we're going to talk today during my section here is about reasonable accommodations during COVID. Now, I want to acknowledge to y'all that nothing in the law of reasonable accommodations has changed. This is all review. It should be the same thing we've been talking about before, well before COVID. And for those of you who say, but FFCRA changed, that's not the Americans with Disabilities Act, which is what talks about accommodations. That's the Family Medical Leave Act. So I want to acknowledge that these rules are the same as they've always been, but there's a big difference this year, and that is we're getting an awful lot more requests for accommodations than we've gotten historically. So what I want to talk about first is the basic rules. Before we do anything else, I want to talk about just the basics and remind ourselves what the rules are, because I think that when we go back to the rules, actually dealing with these things gets a lot easier, because I think a lot of times that once we start the process of trying to accommodate someone, we forget a little bit about what it is that is our duty. And this is one of those places that, to be honest with you, in my mind, is not nearly as complicated as some of the other areas because you have more control. I know y'all have heard me say that on a whole bunch of issues and you roll your eyes when I say it, but it's true. You've got a lot of factual control here. So let's start here with the basic rules. You have to have an interactive communication with with regard to major life function limiting disabilities. That means when somebody calls and says, "Hey, I want a reasonable accommodation," ... That's the beginning of the conversation, not the end of the conversation. That's the point at which you're going to arrange a meeting and you're going to communicate, and it's going to be a back and forth communication. It's a two-way communication. It's a lot of times the way the question comes to me is, I have an employee who's asked me for this accommodation. Do I have to grant it? And my answer for those of you who've asked that question, my answer almost always is, well, I don't know. Talk to me about the fact pattern. Talk to me about what's going on. You must reasonably accommodate a known condition, but you're not required to accommodate something you have no idea about. So if somebody comes to you out of the clear blue sky and says, I have ulcerative colitis, why didn't you accommodate me? You're not liable for that if you had no reason to know there was something going on. But if somebody rolls into your office in a wheelchair, you have to accommodate that condition. You're required to at least ask the question if it's obvious on its face that the person has something that might need an accommodation. So if you're hiring a gym teacher, you can't just not hire that person. You've got to ask the question about whether they need an accommodation, because you may be surprised to find out, no, actually, I can walk. I can do the things you need me to do, but I broke my leg last week and in 2 weeks it'll be over. That's another point that I think is really important. Remember, I might not need an accommodation today and might need one tomorrow. Moreover, the school may be open today and closed tomorrow. In COVID world, that's something we're all dealing with. So remember, this is an ongoing interactive communication. Generally speaking, you have to accommodate unless it causes an undue burden for the school system. However, you don't need to accommodate COVID fear. COVID fear is not a condition. It's just, I'm afraid to come to school. There's no duty to accommodate that. You don't need to accommodate a family's health condition. Now, that doesn't mean they may not be entitled to leave. If somebody's caring for someone who's sick, you are still required to provide them access to leave that they're entitled to for sick leave or for FFCRA leave, which we're going to talk about at the end here. But you're not required to provide an accommodation because a family member isn't sick but has a condition. And that's an important and narrow distinction. Now, to be clear, that's not to say you'll never accommodate someone. You're always free to offer additional accommodations than you're required to. But your burden here is to communicate, not any particular accommodation. And generally speaking, if you meet that procedurally, and you have a substantive conversation back and forth, the courts don't want to, I'll say don't want to, I'm not going to say they never do, but they don't want to invest themselves with a substantive discussion of what is and isn't a reasonable accommodation. But it's the employee's burden to bring to you a reasonable accommodation that they need, to provide you with enough information to understand the nature of the accommodation they need to do the work. But it's your duty to start the interactive communication and to make sure you're communicating about what it is that is burdensome and eliciting a response. That's got to be an interactive communication. Remember that FFCRA also provides, accommodations might include a break, a different room, leave. Some of the really good accommodations I've heard of recently, some of my favorite accommodations that I've heard in the last 6 or 7 months. So I have a number of people who are requesting the face shield accommodation, and generally speaking, it is an undue burden, to my mind, to have somebody who needs an accommodation that puts everybody else at risk. In other words, if I really need it to be hot in my room, I can't require my employer to bring in a propane heater and burn the building down. It puts everyone else at risk. There's got to be some other solution that's safer. Same thing is true with the face shield. If the face shield is not approved, and this is what ISB says and IDPH say, is that it is not approved for source transmission. transmission modification. Therefore, because it doesn't stop the spread of the disease, it puts everybody else at risk. So generally speaking, my position has been the face shield generally is not an acceptable accommodation. But there are lots of things that might involve the face shield that are great accommodations. Like, for instance, a face mask break. You go outside and take it off, and the face shield is there so that the teacher can take it off as they're entering the hallway, take the face covering off so they extend the length of that break a little bit. Or a different room, where they teach from a different room. I've had that a couple of districts that do that. And remember, leave itself may be a reasonable accommodation. But again, that burden is to have that communication back and forth. On to the last slide, the Family First Coronavirus Response Act, Families First Coronavirus Response Act, FFCRA, provides that all employees are eligible for this leave after 30 days of employment, and that includes your part-time employees. It grants a total of 80 hours, up to 80 hours for full-time employment or whatever portion thereof for the part-time employees, at full pay for up to 500 days for self, or two-thirds pay for $210 a day, up to $210 a day for family care if somebody is testing for COVID, has COVID, or is quarantining for COVID. And remember, that's a one-time grant. Now, a lot of school districts are agreeing to extend that grant more. Remember, it hasn't been extended by law past December 30. So if you're extending more, you're doing so out of your own pocket. And remember also that some employees may be inclined to just take that leave because it's effectively free leave. It doesn't come out of anything, and that may jeopardize your ability to stay open a little bit longer. So at least be alert to that. Remember, there's also the grant of 10 weeks at full pay for daycare closure. But remember, if you let them work from home, then they don't have the daycare closure issue. It's true if, that leave is also applicable at two-thirds pay for employees, and that slide says full pay, it should say two-thirds pay, sorry about that. Even for employees who have part closure. So there's a conflict with work, but I work 5 days a week, and my daycare is only closed 2 of those days. The school is only remote 2 of those days. Remember that the FFCRA provides the FFCRA provides that the employee is entitled to that leave. The employer need not grant intermittently, but you can force use, but you'll pay for the amount of time they're out. What I meant by full pay is their pay during that period, not the full rate of pay. The rate of pay is two-thirds pay. Somebody put on in the chat here, I see, but it's all on the school's dime anyway, and that's completely true. There is no reimbursement for a public school district for FFCRA leave, but you should understand that does still mean if you're granting additional leave beyond that, that leave is in addition to the grant that you're already required to provide by the federal government. So again, remember, conditions require reasonable accommodation. COVID fear is not a condition, and it's a condition of the employee, not the employee's family. Interactive communication is the burden on the employer, and remember that reasonable accommodation may be leave.
So, David, a couple questions before we move on from your segment. I'm sure we'll have several more questions on this topic that we'll come back to during our Q&A. But I just 2 quick questions I want to raise now from questions that have popped up in the chat. First, just to clarify again, if the employee is working remotely, but her kids are at home, they're school age, school is remote, they don't qualify for leave, correct?
That's right, because you're presuming you're allowing them to work from home. Remote work is available, and that's the way the employer defeats that. Now, I want to acknowledge that if an employee is actually sick, I think the sick leave rules still apply. It's tough to force someone to work when they're too sick to work. But if we're talking about the child care leave, that's absolutely right. If they're working remotely, they're working remotely. And because we've provided that accommodation, they're not required.
Yeah, I mean, I think that's the way I would view that. Is even though their kids are home, they're still working. And so it's not leave because they're working
Yeah.
and getting paid for working. Although I would also say that working while your kids are home is not as feasible practically as we all might.
It's challenging. As some of you heard even yet this morning, it's challenging.
I want to ask, now, if they said they cannot work while their kids are at home, does that change the analysis?
So that's an interesting question. Cannot work, unwilling to work. You know, I don't. I think that if work is available, I think under the 10 weeks, I think we can allow them to work, but I'm sorry, we can require them to work for the 10 weeks leave. Now, I don't think that's true for the 2 weeks leave because those are all sick leave based. I think for the 10 weeks leave, yes, I think we can defeat it, but I want to acknowledge that, just as Brandon said, that is very difficult thing to do in lots of situations. And so before I took the position, yeah, I'm going to mandate you to work, remember, there's a practical problem here too, which is I've got to actually be able to hold the employee accountable to doing the work. And if they don't do it, I still have the problem of the work not getting done. And so I'd want to at least have a lot more practical discussion about why the employee can't do it, whether it's a willingness issue or a do it issue, and then the risks and rewards with regard to how we're going to, for lack of a better word, force work.
Very good. We've got several more questions on this topic that we are absolutely going to come back to in our Q&A. But for now, I'm going to turn things over to Ellen to talk about some thorny Title IX issues, and we'll come back to some of these FFCRA questions during our Q&A.
Wonderful, thank you. Okay, so I get to talk to you about Title IX, and first I'm going to start with Title IX is not over. The change in administration did not change anything. Biden vowed to put a quick end to things, but it really isn't that simple. This administration knew what they were doing when they used the process of administrative rulemaking. It took 4 years for them to do that. They took 2 years to write it, and they took 2 years in notice and comment period where the public gets to comment. And realistically, to change this, that is what's going to have to happen again. Now, they may find a way to make it take a little bit less time, but that's unlikely to change quickly. I see that as a 1 to 2 year process at the soonest. There was some speculation that they could use the Congressional Review Act to override it with legislation, but because the Senate did not flip, that's not going to happen. There's a 60-day period, and that is going to run before the Georgia Senate runoff races. There could be an option for the Department of Education to not enforce, but that really doesn't stop the courts from enforcing, and therefore the schools would still have liability to follow the Title IX rules as they stand for court purposes. So realistically, this isn't going away soon, quickly. You've got a 1 or 2 years in this before anything changes. It is important to use trauma-informed investigation. I know trauma-informed has become sort of a buzzword in the education field lately. We've even, as a firm, done some reading about it. And within Title IX investigations, you are likely dealing with some trauma, and things like changing the story or body language that you would normally assume is dishonesty is likely to be a trauma response, and you need to be aware of that as your investigation happens so that you can see those things and realize that it's not dishonesty that you're experiencing, that you're seeing, and you can make a note of that because we don't have those live hearings that are going on, that you can pass those along to your decision makers. Now, the most important thing that you need to do right now with regard to Title IX, assuming you don't have a formal complaint that you are working on already, is going to be putting your team in place. And we've got, your investigator, your coordinator, your decision maker, those main roles. But I think the role that is most likely to be overlooked is the informal resolution facilitator. They have a huge role in potentially ending a complaint very quickly and finding a solution that is really good for schools and really good for their participants. An informal resolution we're finding sort of a mediation style into things where the students are going, or potentially employees, I say students, but this can be between employees too, but the participants have an opportunity to really voice what they want in this process. And the schools have the benefit of it not being a potentially 6 weeks to 6 months long process that they have to deal with. But a lot of small to mid-sized schools are going to deal with deciding whether their Title IX coordinator is also going to serve as the investigator or is also going to serve as the informal resolution facilitator. And they just simply can't do both. That is not appropriate. You're going to run into some conflict issues. So some options you can look at, because it is going to be really important to find a good facilitator, is looking to your guidance counselor, your social worker. If your principal or whoever your Title IX coordinator is has a really great rapport with students and keeping an even keel, they might be the best person for that, and it may be best to turn over the role of investigator to someone else. Now, you need to train your employees, and every single one of them, what to do if they receive word that there may be some sexual harassment going on. Actual knowledge is the standard that we have. So if your student on the volleyball team tells that her assistant volleyball coach that she's dealing with sexual harassment, and your assistant volleyball coach is not otherwise employed by the school, does your assistant volleyball coach know to report that to the Title IX coordinator? Because right now the rules say that they need to. So what you really need to do is make sure that everyone knows, your cafeteria workers, your paraprofessionals, your bus drivers, your coaches who are not otherwise employed. Everyone needs to know what sexual harassment is and who to report it to, and that they need to do so quickly. You don't need to overwhelm them with all of the wonderful definitions and things that you have learned in our trainings or other trainings, but you do need to let them know what is sexual harassment and what they need to report. So in your next staff meeting, staff Zoom meeting, staff email, make sure to let them know what they should be reporting with regard to Title IX issues. There are some LGBT issues that can be raised here. The Seventh Circuit has held that Title IX encompasses discrimination on the basis of gender identity under the sex stereotyping theory. So if you have a student or a teacher or anyone that is being misgendered or dead named at school, that can turn into a Title IX issue pretty quickly. You need to nip that in the bud very quickly and make it clear that it is a bigger issue than just contract issue. It is a Title IX issue that can wind you up in front of OCR court pretty quickly. Now, because we're in the K-12 setting, parents have the right to exercise all Title IX rights that students have, and the parent and guardian must be permitted to accompany a student to anything that they need to go to, but that student also has a right to still have an advisor who can but does not have to be a lawyer that is their advisor and is separate from the parent guardian. So your meeting could have two parents and an attorney there at the table with a student. You also need to be prepared to talk to parents about how long this process can take. In one of our trainings, we saw that this is very easily going to be a 6-week process because there are 2 periods of 10 days where basically nothing is really happening. It's sort of a waiting period. Everybody gets a chance to review evidence. So this is going to be a really long process, and if these parents have had experience with school discipline in the past, this is going to look very different than what they've experienced, where someone got a slap on the rear and it was handled in that afternoon. If that slap on the rear turns out to be sexual harassment that has been ongoing and meets those definitions for sexual harassment, that slap on the rear is now not going to look like it's being handled for potentially 6 weeks, which is likely to make for an angry parent. The last thing I have for you is when you encounter your first formal complaint, you need to very quickly create something that looks like what you are seeing on your screen, that documents all exchanges of information and contact that have happened, because this is a piece that is going to have to go into your investigative report. and to throw that on your investigator at the time at which they're trying to quickly turn around an investigative report is not very nice. So go ahead and start one of these very soon, very quickly, documenting everything that happens so that we can just quickly copy paste that into the investigative report, because a lot of these steps are going to be taken by the Title IX investigator, or sorry, the Title IX coordinator, not the investigator. So they're the best person to document that. Finally, you have until December 31st to finish your IDHR training on sexual harassment. There is model training available on the IDHR website, and there are a number of other sources that I'm sure you can go to get that sexual harassment training required for the state of Illinois. This is also a great point at which you can remind all of your employees about their reporting duties under the Title IX rules and regulations.
Thanks, Ellen. A couple questions, and I would just emphasize this. This is all your employees, part-time, interim, student teachers, third-party contractors. Everybody has to have this training by December 31st and then annually thereafter. And I had one of my friends who is a regional manager for Sonic stores this morning complaining, saying, we have to train all of our employees by December 31st on the sexual harassment training, and that is there. Hey, here's a question I wanna throw at you, Ellen. I saw a case filed, I think against Purdue University this week, where the claim is that using a trauma-informed process deprived the accused student of fairness because the investigator found the complainant credible, even though there were gaps in the memory, relying on her. She had been trained that trauma might have that effect. What can we do to make sure that we are both engaging in a trauma-informed process, but also making sure that that process is still one that meets the fairness for the accused student?
I think that's always going to come down to documentation, documenting why you believe that this is the case, that they started to recognize that they remembered that this happened when you reminded them of what song was playing at the time at this party you were at. And when we start building this idea of this documentation of here is the story of what happened and here is what we know about trauma in this wonderful book, which you should all definitely read because it can not only help you in investigations like this, but it can help you have a better school climate and deal with just normal behavior issues that are outside of the sexual harassment realm. But I think that all comes down to documentation is key. I believed it because, you know, they remembered it when we started talking about what song was playing.
Great. Well, we've got a couple more Title IX questions we'll come back to in our Q&A, but now you get to hear from me for a little bit on special ed. You know, I wasn't going to be able to get away from special ed. Hey, we've got a couple people ask about the book.
The body keeps the score. I'll type it in here too.
Yeah,
and
Ellen will put it in the chat to everybody so everybody can see a copy of the book. I've got several of those that I've found to be helpful. But let's talk about special ed. And I've got a few things that we want to make sure that everybody is keeping in mind as it comes to special ed and providing FAPE. And so I just have a couple reminders here, actually 5, that I want to think about. And number one is remember that FAPE is still FAPE. You know, courts and hearing officers, Department of Ed, ISB has not in any way reduced either the procedural or substantive requirement that IEP students are receiving a free, appropriate public education right now. And so whether remote, in person, hybrid, some combination thereof, shortened days, full days, FAPE is the same FAPE. And we have to make sure that IEP students are still making appropriate progress. And I think as we've learned from court and agency decisions over the last several months is that, you know, what we did in the spring was triage very quickly, right? What we are doing now, you know, and I think while technically FAPE was still FAPE then, there was a lot of natural grace and forgiveness. And so I think right now, when we're thinking about remote learning for IEP students, the default, or at least the starting point, should be implementing the normal IEP, but remotely. And I think that the remote learning plan needs to be for the changes that are necessitated by remote learning while still providing FAPE. It's not automatically a reduction in services. I think that we did that in the spring because the guidance from the state said we don't want to do too much during remote learning. And we really provided, in a lot of situations, less service than what an IEP would typically provide for. I think we have to be cautious about that going forward. And whatever decision that we make, recognizing FAPE is still FAPE. Number two is that we recognize that parent participation matters. Right now, remote meetings are possible and encouraged, but the rules still require parent agreement for that meeting to happen remotely. So we want to making sure that we're doing that. Don't overlook prior written notice, and that comes up in a couple very specific ways, particularly with remote meetings. Remember, prior written notice is the written notice of the IEP team's decision after the IEP team meeting before it goes into effect. And so a couple places where that has popped up as an issue with remote meetings, I've had at least one ISB decision where they found against a district for not immediately providing the parent with a copy of the IEP, which serves as the prior written notice at the conclusion of a remote meeting. And kind of scratched my head and said, okay, so it's a remote meeting. Parent's not there. We're not in person. The parent says, I'll come pick it up. And the parent doesn't come pick it up. Whose fault was that? ISB said it was the school district's for not immediately making sure that that copy of the IEP and prior written notice got to the parent. So those are things we want to think about. It also is important when it comes to consent, because remember that parental consent is informed consent that comes after prior written notice. So when we've got a remote meeting, remember we've got to get parents in writing the decision, like the domain paperwork and what the evaluation we're proposing is, before we get their consent, because their consent is not effective if it's not informed consent where they've received in writing the recommendations of the team in terms of the evaluation, for example. So keep those things in mind with prior written notice. And remember that the timelines are not waived unless specifically agreed in writing. And we've got to make sure that that is very clearly documented in writing. Number three right now, not necessarily COVID related, but important nonetheless, is we've got to make sure that we're implementing the paperwork bill, fully. And so they're required to provide written materials to the parents at least 3 school days prior to the meeting, including any drafts. That is now fully in effect, and we want to make sure that that is there. Frankly, I think that's helpful way of remote meetings, to make sure everybody is prepared and enough time to receive those things ahead of time. But I think a couple practical things along with that. When you look at some of the concerns about predetermination and meaningful parental participation, some of the recent court decisions in other states over providing drafts to parents have really turned on the clear cover letter explaining the draft, that this is merely a draft, that it invites parent participation at the meeting, that the intent is so the parents can participate as a fully informed team member during the meeting, and it's not intended to hinge on the parent's participation, but is a starting point for parent participation. I think that clear cover letter is a really important thing to have in place. The paperwork bill this year, as it was amended, clarified the related service log requirement. Those are available now upon parent request for the list of related services that are listed in the statute. And it clarified when the failure to implement notice was required, which now is at IEP initiation rather than a rolling obligation to provide parents written notice when the IEP is not implemented. Number 4, we want to really think about when we've got virtual instruction, what are some key things we need to keep in place? On the student privacy platform, choosing the right platform is the right thing, right? When we choose the right platform with the right privacy settings, and in part, as Christine alluded to earlier, that is not a barrier to being able to provide synchronous or asynchronous instruction. I'll be honest, I get a little frustrated when I hear districts saying, well, we're not providing synchronous instruction because it might affect student privacy or the union objected to it. And I kind of want to say, well, then you don't, I don't think that's the kid-friendly decision. I don't know how we provide FAPE remotely. I don't know how we provide the minutes that we need to provide remotely without being able to provide some form of synchronous or asynchronous instruction to students that might involve student groupings and classes. And I think the key to doing that legally and appropriately is choosing the right platform. Certainly there are some bargaining implications of that, but I do get particularly frustrated when I see people throwing up too many speed bumps to that in my mind are excuses rather than reasons, and are keeping us from providing particularly IEP students with the services that they need. We've got to make sure that accommodations, modifications are happening, and that is especially true when you look at some of the administrative decisions during the pandemic for general education teachers and their IEP students. Are gen ed teachers providing those accommodations and modifications in their remote instruction for IEP students? That's been an issue in many, many cases, and that's there. Make sure we're meeting our accessibility requirements for students with visual impairments, who are deaf and hard of hearing, other communication needs. This has brought to the forefront what has long been OCR's stance, that if we are using a platform that does not meet those accessibility requirements for students who have a visual impairment, deaf, hard of hearing, other similar disabilities, then we can't use that for anyone. If you're using a video that can't be captioned, or that third-party vendor won't caption it, then what OCR says is, then we just can't use that third-party vendor for any student if they can't make their platform accessible to all students. And so those are some of those accessibility requirements that we have to make sure are being met. And what I think is the number one issue sometimes with remote instruction, particularly for IEP students, is what I call the Ron Popeil problem. We can't just set it and forget it. We can't be like, here's your online platform, good luck, right? There's still gonna have to be a proactive approach to making sure that we are receiving FAPE, right? And if a student isn't engaging, if a student isn't showing up, if a student's not completing work, for an IEP student in particular, there's an obligation there on the teacher, on the educator, to make sure that they are proactively following up on that and not just waiting for the student to fail. I think that's a significant FAPE issue, and we're gonna see some of those complaints, and we're already seeing some of those complaints. And then finally, just a reminder here on physical restraint timeout and isolated timeout. Those rules are final, are in effect. Training is the key, and all that training is supposed to be completed by December 31. But there are legislative proposals that would further make changes, both actually at the state and federal level. So there have been introduced again in Congress at the federal level, some changes in the use of restraint and timeout. ISB noted, I think in their October board meeting, that additional legislation on restraint and timeout is becoming a legislative priority in that regard. And so those are things that we need to think about, that there may be further changes coming that could affect things going forward. So that's my quick walk through some of those special ed and FAPE issues going on right now, which allows us to come back to some of your questions on a variety of topics. So I think before we jump in here, Christine had a question to ask me on special ed. So I'll let you, Christine, ask me that question, and then I've got some questions to throw out to the panel.
All right. One of the questions that I had that I think has been coming up a lot is, I think you've heard us say so many times, Andrew F., the standard is FAPE is provided when an IEP is reasonably calculated to provide progress appropriate in light of the child's circumstances. Now, a child's circumstances may be a little bit different during the pandemic. They may be at home, mom and dad may be a little bit stressed, they may have lost their jobs, it may be difficult for them to learn. To what extent should a child's situations that arise because of the pandemic be considered? as part of the IEP process?
I think it has to be considered, but I don't know that it is, again, an excuse to not provide something. I think that the fact that has to be remote, for example, affects how something's going to be delivered. Things that are remote aren't necessarily the same as they are in person, and I think the case law and the guidance recognizes that that's the case. But I think that the idea that somehow otherwise relaxes the FAPE standard, it doesn't. And so I think we have to recognize that FAPE is still FAPE. So I'm going to jump back and go through a bunch of questions here for the panel, and we'll just kind of let whoever wants to answer them jump in, and then we'll keep going through the list of people who have got several questions still popping up. So several people had some follow-up questions on Open Meetings Act issues. In terms of board meetings, it's correct in the ISB Tier 3 guidance, correct, that board meetings can still happen in person.
Yep.
They're still allowable, just not recommended right now per ISB, which I think that's accurate right now. Right now, ISB certainly says, and I think the mitigation records say, guidance says that it doesn't apply to public meetings.
Yeah, but
I also recognize that even though it doesn't technically apply, it's still a recommendation.
Yeah, I think it's important also to note that in Tier 2, the 10-person cap did apply, and now in Tier 3, they're saying, well, these don't apply to board meetings. I've cautioned people, one, every additional person in that room exposes the board to a little bit of additional risk. And remember, the purpose of the mitigations is to slow the spread down. And so if you have a spread event at your school, obviously that's going to jeopardize in-person learning. That's going to jeopardize continued operation. So to the extent that you can minimize attendance at that meeting, I think the goal is to do that. Now, I acknowledge there are reasons that we may want to be continuing to meet in person when we can. But again, whether the fact that the Tier 3 mitigations ISB saying we're not going to be the police and come in and address it for you doesn't mean a plaintiff's attorney won't come address it with you later if you just disregard entirely. So do what you can to keep people safe. That's got to come first.
So on that COVID and meetings question, what about a coach running an optional get-together on personal property, not at school? Do we have any concern about that whatsoever?
I think Christine does.
Answer the question.
I think my concern would be whether in court that could be considered to be under the auspices of school authority, whether or not it is at school grounds. If you have school personnel who's encouraging, for lack of a better word, students to get together, I think things would get pretty gray pretty fast. So
yeah.
I
totally agree.
If you look at some of the case law about what is a school activity for liability purposes, it looks at the ability of the school to have control over the promoting it, funding it, but also control over the person organizing it. And if it looks like it's connected to an official school activity, it is an official school activity. And I think we have to be cautious about where that line is. I'm not sure that a coach doing something, even if it's not at school on their own time, but with their players from their team, that's still a school event, and that liability is still there, and that's still not okay in my mind.
And they still look like a coach. The kids' their only cognition of that employee is as a coach, and therefore, to my mind, we have a duty both to distance ourselves from it publicly. Even if it's embarrassing publicly, we have a duty to distance ourselves from it, and we also have a duty to do what's within our control with regard to the employee to discontinue it, including straight directives, perhaps progressive discipline, as well as clear a notification as there may be that this is not acceptable or endorsed by the school.
I completely agree, David. I think it is very important to point out in writing to every school employee, volunteer, these are our expectations and requirements for being safe, so that there can be no confusion as to, well, I thought it was okay because it was in my house.
Yeah, and I think that as a segue to our next question, which is not necessarily a COVID-related question, As I had that come up this week with like a PTO or booster organization, where even though they're technically separate, they use the school's tax exempt number, which is a financial entanglement, which makes anything they do potentially come back to the school.
Right.
So that leads to a PTO question. So do PTO Facebook pages have to follow the same guidelines of free speech as the school or district Facebook page? For example, a PTO is a Facebook page, people are upset commenting. Can the PTO delete the post or delete comments or block people in that regard?
Well, Brandon, I think you framed the answer in the question. Are they a separate entity? Do we have any control in the first place? If they're a totally separate entity, then it's a little bit like McDonald's saying to Wendy's, you can't pull the chicken sandwich. It's Wendy's. That's totally separate entity. And if they're completely separate entities, they're cognizable as separate entities, they're totally different entities. And by the way, it's certainly for the best for the school. We take donations blindly then, and the PTO becomes a totally separate organization. If you can segregate your liability that way, it's better. But to the extent that they're affiliated with the school and PTOs like this, booster organizations, lots of different organizations that serve the school or serve with the school that operate effectively informally but under the auspices of the school, there's some risk there that someone views that as being school speech and therefore somehow endorsed, because some of those parent-teacher organizations have direct endorsement from the school. I know that last year my kids that went to a school where the principal of the building was the chair of that PTO. And where that's the case, it sure looks like school-endorsed speech. And then I'd be very concerned about taking down posts and limiting people's right to free speech.
And I guess that I want to make sure that we didn't get ahead of ourselves, because some people might be saying, well, why can't we delete comments off the school's Facebook page if we don't like them or they are negative? And I think that goes back to the very clear First Amendment case law that as a public entity, when we create that limited public forum, then we can only regulate the time, place, and manner, but must be content and viewpoint neutral in our regulation of that. And so there's, I think, the most important or famous or case of recent genre on that is the Second Circuit Trump case, where the president was blocking people on Twitter, and the Second Circuit held that that was a limited public forum because that was an official account, and blocking people who disagreed with him was a violation of the First Amendment. The same would apply to a school social media account 100%. Where we can't just delete negative comments without raising a First Amendment issue. All right. Back to a COVID question, should we be having faculty holiday luncheons right now?
Oh boy.
Are they online functions?
I will say I had a Zoom third birthday party this weekend, and it was fantastic, right?
We did the same thing 2 weekends ago with our 7-year-old.
But I attended a third birthday party for my daughter this weekend via Zoom, and I think that's the way anything that's not necessary, right? I would say a board meeting is different than a board, holiday party, right? And I don't think I'm having any school-sponsored voluntary, not necessary activities right now. Anybody disagree with that?
No, and in fact, the ISB IDPH guidance from the other day says under Tier 3 mitigations, anything that is not an executive function of the public body is prohibited as a gathering. So you can perform education in person, you can have a school board meeting in person, you can't have, the ISB's guidance says no staff meetings in person. So yeah, no, I don't think we can do holiday luncheons in person. I don't think that's permissible at this point.
So 2 follow-up questions to that. 1, what if the teachers do it on their own?
I mean, I think we have that same endorsement concern we had before, right? I mean, I think our duty fundamentally is to identify the issue and the rule to the employees and to remind them that our continued operation in person relies on them not violating the rules. And I had this at the beginning of the year. We had a teacher who got in the car with got in a van with 6 other teachers and went to lunch. And one of them, unbeknownst to the group, had COVID. Well, that shut down 3 entire grades. I mean, that's a disaster. And again, they were all there for a training during the day, and then they got in the car and took off their masks in the car. And I mean, it's a disaster that feeds on itself. My advice to you is that you give them the directive not to do those things, and that you supervise during the time they're within your employment zone. To the extent they get outside your employment zone, people go have a party on their own on Thanksgiving, you can't prevent that. There's a very limited reach of the school, and it's to protection of the educational environment.
Yeah,
I'm sorry.
I was my war story on that, where I had a district who had to go remote for 2 weeks because all of their transportation staff had a prayer circle before school. And I guess I could go find my Bible on the shelf right here and find where it says that you have to be within 6 feet of each other when praying. I don't see that that's a requirement. Maybe I shouldn't get that far into people's religious practice. Maybe those bus drivers practice religion that requires you to be holding hands while you pray. But I think that they could have done that while socially distanced, and that school could have been in session for those 2 weeks. But because they weren't responsible enough not to socially distance during that activity, that school had to shut down for 2 weeks because they didn't have any transportation personnel. I think that's troublesome.
Yep.
And I think the one thing that I would add too is I'd want to make sure that these directives and guidance are in writing and that they are clear and consistent. I think one of the things that worries me is that we can tell people things in separate classrooms and they might be getting different ideas about what that means, or that, if we were to have an instance later down the road where we said, oh, we promised, we told them, well, it's hard to prove that happened unless we have something in writing.
So the second and related question to that are questions about, ISB's guidance saying no staff meetings. What's a staff meeting? And so the question is, if the superintendent and the union president and the principal are sitting down having a conversation about something, is that a staff meeting that's currently prohibited?
Boy, that's a really interesting question. I don't think that's what they intended. The superintendent and the principal can't meet. The principal and the union president can't meet. But my question is there a reason that we can't do it remotely? Because obviously, to the extent that we're meeting in person, we're increasing our risk. So the fewer times we can meet in person, the more we can have remote. Even if we had one of those people remote, we are improving our immunity under the tort liability shield. I think they intended larger groups of staff. They didn't mean 2 teachers meeting in a room. They didn't mean the superintendent and principal meeting in his office or her office. But I think that that there's risk anytime we bring more than one person into the room. We're creating additional risk, and thus we're incurring risk that somebody's going to say that was an unnecessary meeting.
So I want to go back to the FFCRA and a question here. If a teacher is eligible for the 10 weeks at 2/3 pay, can they use their own sick time for the other 1/3 time to get full pay? If our collective bargaining agreement doesn't provide for a third time but only half or full day sick time, does that influence what you would do?
No, no, you can't do that. I mean, you could agree to it, but no, the employee doesn't have the right to that absent an agreement to it, because it's not sick. You're not sick under that 10-week provision. You're providing care for a child. It's not sick time. And in fact, under the FFCRA technical rules, it says that unless there is an agreement otherwise, those days are to be used in full day increments, which means that if we're not providing, meaning sick leave is used in full day increments. So we're not allowing them to take it in 1/3 day increments unless you've got a practice allowing your personal leave to be taken in 3rd day increments, which I can't imagine, but I suppose it's possible. I mean, I do know there's some districts that allow vacation time in 1/4 day increments. I suppose they could supplement those using those, but otherwise, I don't know, unless you'd agree to a new practice with the union, sick leave by definition requires someone to be sick, and the 10-week leave explicitly excludes when there's care provided because someone is sick.
Title IX question. Question is, I know we have to put the notice of our Title IX coordinator, have them identified and posted on our website and other places. Do we have to name and post the information for the investigator, decision maker, and formal resolution facilitator?
That is not something that you need to post on your website, but it will be information given throughout the process. You will eventually name them in some of the notices that you send out, and they will be named in the investigative report and such.
And of course, all have to be trained.
And trained.
A special ed question here. If you've got a student who has a one-to-one paraprofessional or assistant, can that assistant be utilized during remote learning to deliver instruction? The teacher does instruct the student, but the TA is also providing instruction. And I think the answer is they're supplementing the instruction. The instruction is coming from the licensed teacher. What the TA is doing, what the one-to-one is doing, is not providing instruction, but supplementing that instruction. I think that's the only way that can really be permissible, even in a remote situation. Any of you disagree with that?
Nope.
Nope.
And in fact, I'd point out that there's been loosening of the rules with regard to supervision during this year, supervision and licensure. So I think that so long as we've got licensure present, so to speak, we're pretty safely within the rules for this year. That all goes out the window next year, but this year I think we're fairly safe.
Another special ed comment / question, which is frustration with which I also share. Our district wrote amendments, and the parents gave permission for us not to do evaluations until the lockdown was done. ISB has told us that's not appropriate and we have errors. Well, I've had to push back with ISB on that because they put out guidance that said we are encouraged to reach mutually agreed upon extensions of time. And I think where we've had that concern is where those extensions of time maybe weren't in writing, or we didn't provide that with ISB. But I've pushed back hard on them to say, you can't change what you told us. You actually use the words, you are encouraging us to reach those extensions of time with parents, and you can't come back and ding us later because you were encouraged. And what I found to be happening with that is in ISB's grand lack of competence, they have been not sharing their own guidance internally, where the people doing the investigations haven't been given the guidance where they were told that they were encouraging these extensions of time. And so I think we just have to remind ISB of their own words, and we can move forward from there. Question, how can we do training on restraint by the end of the year with the current COVID mitigations? I recognize that is difficult. I think that, now what's clear is that everything except the actual demonstration of the physical holds can be done virtually or online, but that the actual physical restraint, physical holds, the regulations make clear must be done in person, and ISB is stuck to that. And I think that right now, the key there is increase the PPE, limit the amount of time, and limit the number of people are interacting with, and that's how you get that accomplished.
Brandon, there's a similar question here that's been raised. We have intruder training for each of our buildings scheduled this month. Would you advise to postpone those because they would be considered a staff meeting? So another training question.
I mean, I think that the issue is how those occur, because we're still required to have a drill within so many days of the beginning of the school year. And so the school code still requires that, that drill to occur. And so I don't think a mandated drill is a staff meeting. I think that the group training part could happen virtually, but the actual drill may still occur. Right? Anybody think any differently on that?
No, I do wonder whether it would be worthwhile, though, to be able to consider and document beforehand those safety factors that were considered beforehand, how those were considered, and what the district resolved to do, and make sure that you document those in writing to make sure that you can prove, hey, we were aware that these were concerns, we considered them, here's how we took reasonable steps to respond to those and meet our statutory obligations.
Totally agree.
So another sort of broader IEP question, are schools still held to the same standard when a parent of an IEP student chooses remote learning when the school district is offering in-person learning? Not for a medical reason, but because they voluntarily chose an in-person learning. We know that in-school learning is better than remote learning. So are we held to the same standard? The answer is yes. Because what FAPE is the responsibility of the IEP team. And even if the parent voluntarily wants remote learning, the IEP team still has the ability and authority, and in some cases the responsibility to say we can't provide FAPE that way. And unless it's a statewide shutdown, IEP teams have that discretion and need to exercise it. And so I don't know that I want to get into the bad or worse, but if it's not FAPE, right? If a student isn't receiving FAPE with remote learning, then the IEP and in-person learning is available and the student isn't medically prohibited from in-person learning, I think the IEP team has an obligation at that point to consider bringing that student back in person. Any thoughts or disagreement with that?
Nope.
This one sounds fun just by the first sentence of it. An employee has taken out a petition to run for the school board. So I just know that wherever this question is going, it's only getting better from here. He told me one of the first things he's going to do when he gets elected is to remove a letter of reprimand in his personnel file. Well, that's even better beyond that. It's my understanding as an individual board member, he has no authority to do anything with the personnel file. Is that correct?
Well, I'm going to jump in here and first of all acknowledge that we have an inherent legal conflict that's been tested again and again with an employee as board member. So the first question is he actually going to get on the board in the first place? Is she actually going to get on the board in the first place, whoever it may be? Because there is a legal conflict. Then even if they get on the board, obviously the board has difficulty because it's a personal conflict, not a legal conflict for the board. It's a conflict for that person. There's going to be statutory questions of standing as to whether we can challenge or whether that really needs to be a vacatur action by the state's attorney. So then there's the question of, even if they get sworn in, do they remain sworn in? And then the final question, can they remove something from their personnel file? The board acts by a vote of the majority. Therefore, the only way that person gets a reprimand removed, changed, etc., is by convincing a majority of the board, because as an individual, while they may have access to certain records, they don't have the ability to change those records. And of course, modifying certain records carries criminal consequence when not authorized to do so.
And in fact, the Illinois Supreme Court held this summer that the Local Records Act trumps agreements to be able to remove things from personnel files. So I don't think anything's coming out of that file. FFCRA question, and I do want to because of all the FFCRA questions, I want to emphasize something that David said at the outstart, which is right now technically it expires December 31st. Now I see today there's press conferences in Washington of additional COVID relief bills and what may or may not happen in Washington, and who knows what the president will or won't sign at this point, and I don't know where that's going to go, but technically that all ends December 31st, and it's very possible. And so this is my big sort of asterisk on everything we're saying. The new bill could change all of this, right, by having different language. And so if it gets extended, my guess is it gets extended in some modified form. It may not look exactly the same way. But given the existing rules, the question is, is it cumulative up to 14 calendar days, 10 work days, 80 clock hours for the employee? Well, the issue is it's really 80 hours or 10 full work days, whichever is less. Right. It can't be more than 80 hours, but if someone only is regularly scheduled to work 35 hours a week, it's whatever their status is. Whatever if they're a half-time person, they get 10 half days, right? It's whatever that equivalent would be of them based on what they work. So it's for a full-time person, I think the easiest way to think about that is 10 work days. For a part-time person, it's 10 part-time days, whatever that looks like for them.
And I saw somebody in the chat said, did you say that we're not getting funding for that? And at this point, as of this time, there is an exclusion within the FFCRA funding bill that was supposed to provide a tax deduction for public and state agencies. And so, unfortunately, school districts are covered within that exemption. So yeah, I'm afraid there isn't necessarily any tax relief coming, because that tax relief comes by way of deduction from certain business expenses, which school districts aren't generally entitled to.
What about those people who need more than 10 days? And they're not yet released by the health department because of continuing to have symptoms or more severity.
Well, I think that goes back to our regular leave entitlement. I think the leave entitlement is what the leave entitlement is. I've had some school districts that have wanted to, when the first case came up that exceeded that, wanted to be generous with the first person. I've cautioned that doing that may establish a practice, and also it's a mandatory subject of bargaining. Giving money away for free to one individual still implicates bargaining with the remainder of the unit. So you have to have union agreement when you do that, even if you do it out of the goodness of your heart. But remember also that the disease travels quickly, and it's very possible you may have more than one, more than two, more than 12, more than 50 at any given time. And that could be a fairly large sock of leave we're talking about. I have one district that that the union had proposed 550 days total. And those days aren't free. We're still paying for those days. That's a lot of 550 days. Even if every employee is only using 5 days at a time, it's still 550 days that we've got to procure subs for, that we've got to provide work for, we've got to get coverage for. That's a lot of potential coverage. That's a lot of potential money out the door. So we should be careful not just to think about going to the end of this year, because I recognize some of us are concerned that employees are going to get quarantined and thus not be available for work because the money's expiring. But remember, we don't know what happens next semester. We don't have any idea whether next semester we're going to get any more days. It may just extend the number of days, extend the time to use them. We don't know whether those days whether we'll get more days that we can give, and we don't know whether that will be overlapped if in fact we agree to more days. So what if we grant 550 days and then the federal government gives us an additional 50 days of COVID relief? It requires us to use, well, now we've just padded everybody by 550 days, and of course there are TRS implications for all those things. So I'd caution people to go real slow on that stuff, and while you might be generous and want to be generous, remember, if this becomes catastrophic in your district, we're going to go back to the bargaining table at some point, and that's when we're going to have an opportunity to fix whatever cataclysmic event happened in the school district, and you can fix those things at the bargaining table.
So we got a whole bunch of the same question, which is, can you legally just not allow any comments on a school's social media page at all? And
legally or factually?
Well, yeah, I mean, legally, I think you don't have to create a limited forum. You can,
right.
You don't have to allow comments, and if you don't, you can restrict time, place, and manner, which is we just don't allow comments. Whether that is possible in all of your various social media platforms, I don't know that is always possible.
Yeah, some platforms prohibit your elimination of comments. Facebook, for a long time, I don't know if there's a way to do it now, but I know at least until 2 years ago, they did not allow you to prohibit comments. YouTube allows you to restrict comments entirely or restrict them so that they have to be reviewed first. But remember that even when you switch that to review first, you're by and large letting everything in that isn't violating of the clear established forum rule, which might be marketing. You might be able to. I suppose you could probably remove marketing and clearly pornographic material, but just about anything else is going to get right on through on your page. So it might be better. You might be better off in those situations just turning those comments off entirely.
Can a school district require an employee to take a COVID test? Well, I mean, the ADA restricts medical inquiries to job-related and consistent with business necessity. We have under the school code the ability to require a
24-5
physical examination when certain things are met. So there are situations where we could do that, but that does, but it's got to be job-related and consistent with business necessity, and that I think is stretching it.
And it creates a whole lot of additional issues, too, because under 24-5, we've got to pay for whatever the examination may be. In some areas, COVID tests are readily available. I just read in our local newspaper that the University of Illinois is going to start providing them for the community in a couple of weeks. They may be readily available in your community, but in some communities, they're not readily available. They're very difficult to procure, and they take a long time. And, of course, if it takes 3-4 days to get scheduled. My brother took one in the Chicago area, and it took him 4 days just to get in to get the test. Are you going to be paying for your sick leave, not FFCRA, during the period of time? And when I say your sick leave, I mean, are you going to be providing them leave generally? What reason do we have? Do we have an FFCRA that they're required exclusion? Are we submitting them to COVID tests because we're trying to get them back, or are we submitting them to COVID tests to exclude them because we think they probably have COVID, in which case they're going to be eligible for FFCRA as well as sick leave time? Are we going to be putting them on administrative leave because we think they engaged in a behavior that was risky and we're trying to keep them out? I'd be really careful with that, because I think, then we're going to have the additional question eventually as to whether we're applying this new standard universally or whether we're applying it narrowly. And remember, we can't, just because we send them out for the test doesn't mean we're getting access to the result. So that's an additional bridge we got to cross, is to make sure that we get that information and that we know how we're going to get it, because the employee has to release it to us.
Are live in-person collective bargaining sessions now out of the question?
For now. Yes, for now. I don't.
Right now, I don't think IEA is permitting their folks to have in-person sessions. My last communication with them this past week. So I think that's probably where things are at.
Yep.
If a parent has a doctor's note saying that for health reasons the parent cannot wear a mask, can we keep her out of the school and do all business with her remote? My answer to that is yes. I don't think that the parent, there's nothing that we can do with a parent that's not remote, where that's not, in my mind, a reasonable accommodation to do things remotely. She has to meet our visitor regulations just like everybody else. And so I would say we're doing our business with that parent remotely at this point.
Yeah. Yeah, I mean, I think we got to have a conversation with her. I don't think we just send a letter and say it's all remote. But that conversation, I agree with Brandon, is really short because I think that is the reasonable accommodation, is remote meeting.
Title IX policy question. If we've posted all of our board policies on the school district website, does that meet the requirements of posting the Title IX policy on the website, not including the training materials?
Needs to be prominently displayed. So if this is hidden within a document that is titled board policies, I would say no, that does not meet. I think you need to have something more prominently displayed as a section of Title IX within your website, or your Title IX coordinator needs to be listed there, and your training needs to be listed there. So I think if it's just, within a document pasted on there. It's not easily findable. I don't think you're meeting things there. I think you need to have it more prominently displayed than that.
So if an outbreak in the kitchen staff occurred, in which we did not serve meals on one day in coordination with the county health department, district paid kitchen staff for that day, one member of that kitchen staff was on paid maternity leave at that time, does that employee on maternity leave get credited back the one day?
Did not serve.
My mind is subject to potential bargaining implications that no, they were already on leave. They wouldn't have been there anyway. I think that's different than if it was an act of God day where all of a sudden is no longer a day. But my mind is no, unless any of the rest of you guys disagree with that.
I agree. I think it's a bargaining issue.
Yeah, I was going to say, I think it's a bargaining issue. I think you got to look at the past practice there because, to my mind, one thing I'd be, first of all, it strikes me that everybody's out the sick day anyway, but I'd want to know what the past practice is. I'd want to know what we've done in active God day situations. I'd want to know what we've done in other outbreak situations, if we've ever had any outbreaks. There's a lot baked in there that has to do with past practice, and I'd kind of want to know what the practice is before I decide. But I agree, as a baseline rule, I'm not necessarily required to allow somebody to credit back a sick day simply because a different kind of sick days was required.
Hypothetically speaking, an employee boards a plane from Mexico yesterday. Can we require a 7-day no return to work period per CDC recommendations? And if so, could the employee use the FFCRA days for that?
Well, I think, yes, they can use FFCRA because I think it's a qualifying condition, but I'd offer, before you do that, you better check with your local health department to make sure that it's travel restricted, because, and I'll tell you the case that scares me. The case that scares me is real early on in this, like February. I was sitting in a meeting with a bunch of other attorneys, and somebody said, my health department said that we've got an employee or a student who came from some remote country where they had exactly 0 cases of COVID, and that student isn't allowed to come to school for the next 30 days. This is real early, folks. A quarantine period hadn't been defined yet. And every lawyer in the room went, and one of my colleagues sitting next to me said, sort of muttered under his breath, that just sounds racist. And I thought, I couldn't disagree with that. That sounded to me at that point, that early on, where this country was 0 cases and we're saying the kid can't come back for 30 days, something about that just rubs me the wrong way. So before I make the decision myself on an executive basis, we're restricting from another country, particularly where the United States is at this point, I think, is about as rough a place as you can be with the disease. I'd want to at least check in with my local health department and make sure they're going to say, yeah, that country's travel restricted, because under the Health Management Agency Act, we may not have tort immunity under that. It's possible. We don't necessarily know yet, but they definitely have tort immunity to the extent that they make those decisions. And so I'd rather that they're the ones weighing in on whether there's travel restriction exemption as required there.
Next question here. If a student cannot wear a mask or shield and cannot tolerate a face covering, should the school allow the student to return and follow social distancing, extra PPE for staff, etc.? Well, I think we have to consider it, but I don't know that is ultimately the outcome. I think that what's been very clear in the OCR guidance is that with a student with a disability is unable to wear a face covering, that we have to consider accommodations that would allow the student to attend safely and keep other people safe. And then if we can't do it in a way that keeps other people and the students safe, then remote learning may have to be the option for that. And so that's going to be a very case-by-case decision. Is social distancing and extra PPE possible and feasible in that situation. If so, then that could be a potential accommodation that would be considered. If not, then that student may have to be a remote learner for that period of time. If there's a special education student that's been provided technology for services and instruction, the parent wants paper packets instead. Does the school have to provide the packets? The internet is available and technology has been provided. That's an IEP team decision, not a parent decision. And I think if the IEP team says paper packets isn't going to provide FAPE, the technology is how we can and will provide FAPE, and it is available, then that student is then just absent or truant.
I would want to verify and make sure that the child does have access to technology, even if it is available. If for some reason the child is not able to access it, if they don't have a computer at home or there's something else, I'd be curious about that, but yeah, otherwise I'd agree.
All right, let me keep scrolling down here to see if there are some other questions that we haven't answered. I think we've talked about negotiations, falling as part of a meeting.
Yeah, I mean, certainly you can have closed session discussion with the board in a board meeting about their negotiation strategy. I don't have any problem with that being exempt from the rules. But to the extent that what we're really doing is just having negotiations, I think it's safer to presume that needs to happen remotely right now. If you're asking me, could you defend it? It's really a board meeting. We're under 10. We're going to be 6 feet spaced. We're not going to have any more than 6 people at a single table. Could you defend it? Sure, I could defend it that it's in the auspices of a board meeting. But do you want me to defend it, or do you want to avoid the lawsuit in the first place? And I'd say that your safest measure of avoiding the lawsuit is to do the negotiations remotely if you have to, or postpone them if you can.
Another bargaining question popped up here. Are you seeing any salary trends in bargaining? Let me start by saying, honestly, it's all over the place. And the reason for that is you've got districts who are in different situations as it relates to minimum wage and minimum teacher salary, as well as the budget concerns in the pandemic. And so I would say what I'm seeing as the trend is I've never seen it vary so wildly, from districts putting in place a freeze to roll things over for a year, to districts giving the biggest raises I've ever seen just to keep up with minimum wage and minimum teacher salary requirements. And so I think that in my mind the trend is that there isn't one, because also you had some people who had already made initial proposals pre-pandemic, and then those who hadn't started bargaining yet, right? And so everybody was kind of in a different place this year. I think that at this point, I think we're seeing people trying to be a lot more conservative given the budget nightmare, is that a fair word to say, that is looming in the future. But at the same time, I don't know that I predict that there's going to be any sort of relief from minimum wage or minimum teacher salary requirements. I don't see that changing at all.
I was told early on in conversations with the governor's office, don't even bring it up. That is firm. That is a done deal. That is not even up for discussion. So I've had a lot of people who've asked me the question, hey, is that going to be eliminated? Are we going to get some relief from it? Are we going to get some funding? And I've been told the answer is no, on all pieces. So if it were me and I were in your shoes, I would be bargaining with the presumption that, well, first of all, minimum wage is already here. I've already seen claims on it. So one, understand we're already in those changes, and two, as to minimum salary and minimum wages, they're coming as they're coming. They're statutory. You have to comply. They're not maybes. They are musts. You must do what they require you to do. I would say that I saw a lot more rollover contracts last year than I've seen in a long time. A lot of those are going to come due next year, and I think it's going to be tougher to get a rollover next year than it was this year. I think a lot of unions weren't sure which way was up before, but if your messaging has changed about salary, if you are more concerned than you were before the pandemic began, it is time to start getting that message out to your union representatives so they are aware and not blindsided when you go to the table. If you start talking about this on the day one of bargaining, you got no chance of getting done without trouble.
I think one of the other things in that vein is I think that we've been through a couple of years where we've seen relatively fewer RIFs and reductions in force because with evidence-based funding and other things, the people haven't been there. And frankly, in previous years had done a lot of riffing. And I think that maybe we've gotten out of the habit of remembering some of those key practices. If we might need to look at RIFs this spring, that you've got to have that RIF joint committee meeting no later than today, December 1. Actually, by December 1. So if you had a meeting today, I would argue you met today. So if you need to have that RIF joint committee meeting, we understand if you run away and are calling your union team to be like, let's have our joint committee meeting today, right? But if we don't do that, those are things that may interrupt the RIF process, and understanding that we also are in a very weird no man's land between what the school code requires for RIF procedures and what the Seventh Circuit has held as constitutional. Right. And you've got different tenure teachers who are going to fall in different categories of that constitutionality argument in terms of those who acquired tenure pre-para and those who acquired tenure post-para, potentially having a difference there. So we've got a mess that the legislature needs to fix. And so as you're considering RIFs, don't overlook some of those hurdles and speed bumps that are going to be a little difficult this year.
Yeah, agreed. And remember that we've got to consider the effect of what the evaluations look like in our district as well. Whether they look like, anyway.
We've got substitutes who are purposely only working a couple days a week so they can claim unemployment. Can the district stop using these subs without repercussions? Well, without repercussions is broad. Ultimately, there's not an ongoing expectation. It's not going to prevent them from continuing to claim unemployment, and in fact would probably just strengthen their argument to get unemployment in the short term. And then if we retaliate against them for exercising their rights under the Employment Security Act, that also would be a concern. So I think that would be a situation where I would tread very carefully in terms of the reasoning why we wouldn't be using that sub anymore, particularly if we have a hard time finding subs right now.
I was going to say, we're right in the midst of a sub shortage. Shortening that list where we don't have malfeasance of the sub as to work rules, it may come back next year in an or even next semester in an unpleasant manner. So be alert to that issue. I'd also point out that generally the reason we don't give subs letters that say, and hearings before the board that say we're not happy with your employment so we're discontinuing it, is because subs have no reasonable expectation of continued employment. That was what Brandon was saying at the beginning, no ongoing employment expectation. They have no reasonable expectation of continued employment. So usually what we say to them when we stop using them is you remain on the sub list. I haven't needed you lately. Which, again, it's consistent with their expectation. But if there's a I filed something, then you stopped calling me, and you're still calling other people, that doesn't mean that it's legal for us to retaliate against someone for exercising their rights. So just because there won't be a written paper trail, remember the other side of that also means there won't be a written paper trail the other way. There won't be a written paper trail that shows why we don't call you, and therefore we're really reliant upon that timing issue. And as Brandon said, I'd tread very carefully there because it sounds like that timing issue is awfully close in terms of causation.
Well, we've got just a couple minutes left here. If anybody has other questions or any other comments from Ellen, Christine, anything that we've talked about that's raised another question you think is worth talking through before we wrap up here in the next few minutes? Well, let me say this while we wait and see if there are any questions here, which is, again, just thanks to everybody for all you're doing. I know this is a year unlike any other, and I know it sounds like a broken record, but I know I talk to school administrators all day, every day. You know, I hear what's in your voices, and I think that those are things that we just want to continue to try and be a resource for our clients in that regard, because I think that's I promise we're not trying to overcomplicate your life with the law. We're trying to keep you out of trouble. And hey, a couple good questions here popped up. So let's one's an FFCRA questions and one's a special ed question.
Oh,
so
cool.
I think those would be great things to close things out with. First is an FFCRA question. Does it apply in this situation? A teacher requests expanded FMLA leave because her child's daycare doesn't want their child to attend daycare because of the potential exposure from the mother to the child. The daycare is not closing, just not wanting to offer her child service.
Ooh, that's a good
I don't
question.
know that meets the definition of a closure. Do you?
So first, that was my first instinct. It was about what I was about to say, that I don't know that it meets the definition of the daycare is closed. But remember, it also says or unavailable. And one of the things that worries me in that situation is I don't know that, I mean, Brandon, I know we've discussed this a number of times, what constitutes unavailable, because we keep getting these questions that are founded in, well, but I know there's somebody down the road and who could theoretically do it, but they won't send them to that person. And to be honest with you, I don't know that I want to get into those discussions too far into the weeds about proofing on whether the daycare is available. To my mind, your solution in most of these instances is going to be remote work, not remote work availability to the extent that it is available, not denial of the leave. I think in most of those 2/3 pay situations, remember those first 2 weeks are unpaid and then it's 2/3 pay. So to my mind, I'd be inclined to try to find a remote work situation for the employee to the extent I am able to do so if I'm trying to defeat the FFCRA entitlement.
And then our special ed question, are we seeing any claims for compensatory services yet? And the answer is yes. Okay. Now, I don't know that the floodgates are opened yet, but I think that we've seen a number of attempts through various forms, whether that's the class action lawsuit in New York, which has finally been dismissed, at least for the time being, and where that goes. I think that both through due process, through the IEP process, and through ISB complaints, certainly have seen requests for that. I think that the important thing for me on that compensatory service, without giving you an hour lecture, the short version is, remember, those are going to be individual case-by-case decisions. Whether a student didn't receive a FAPE and what we need to do to make them whole if they didn't receive a FAPE. It's not automatic. The fact that something was remote versus in person wouldn't necessarily entitle a student to compensatory services. It's more that something couldn't be provided at all in that regard. And so when we are thinking about those issues, we need to be recognizing this is an individual decision by the IEP team about the extent to which services need to be there to make a student whole. And in that situation, we would do it. And I think that's a situation where I would differentiate between when the service was available but the student wasn't, versus the student being available and the service wasn't, and services that just don't lend themselves to remote, like maybe physical therapy. Maybe we're choosing not to provide it at all. Then we know we're going to owe it as compensatory service at the back end. But where we're doing speech remotely rather than in person, that you're still getting it, right? And so in my mind, that doesn't create an entitlement to compensatory services on the back end. So yes, we're seeing decisions from courts and hearing officers on that. We're seeing that being raised in due process and at the IEP level as well. And I think the key there is to go back and say, what did we not provide that we're required to have provided? It's not that remote learning was bad. It's that we didn't provide something that should have been provided. And I think that's where we need to focus those decisions back to the IEP team. I've also had some parents who want us to say ahead of time what the compensatory services are going to be, and I don't think you can make that determination until after we see what hasn't been provided and where the student lands. If they still make progress, I mean, let's say your student gets 0 services and they still meet all their IEP goals. Well, then technically they've received FAPE and they're not going to be entitled to services on a FAPE perspective, although ISB typically will, on a compliance basis, require service to be made up out of compliance. So we've got both a compliance and a FAPE issue that we have to keep in mind for those services. Christine, any other thoughts you have on that piece to things?
No, I think you've covered it really well. I will note, I think it is important to emphasize, as you did, normally when we get these requests for compensatory services, they're in the thousands of hours, and it really is important, like Brandon said, to just take a data-based analysis saying, what does this child actually need, and where are they at?
And what did we actually not provide?
Exactly.
And that's where the documentation and the service logs become particularly important. So, well, any closing thoughts for anybody else? If not, again, thank you. Have fun heading off to all your para-RIF joint committee meetings this afternoon that you're all going to run and have now. But
thanks for all you do.
Yeah.
The end is near.
We appreciate you. Well, hang in there, take care, and we'll talk to you all soon. So thanks
Bye now.
everybody, and have a great day.